just going to press record, because sometimes I forget, and that will go on to our YouTube channel. So that will be accessible afterwards, and we will send out a link to you so that you can view it again and share with anyone you think would be interested. If you keep yourself on mute, you will not come up on the screen at all, so you don't need to worry about being recorded. So I think that's all the ground rules, apart from if there's any weird behaviour, inappropriate behaviour, I will ask you to leave. This is a safe space for learning, sharing ideas. And we came up with these tech talks at the start of the last lockdown. So we've got about 14 in the series now, fantastic subjects, all from creating a Twitter persona, getting into tech, cybersecurity, being innovative, lots and lots of different career journeys. So please do check them out on YouTube at Leeds Libraries. If you want to talk about the talk today and say how you felt, I don't know, and a comment on social media, we are at Leeds Libraries as well. And you can find out about our opening times at leeds.gov.uk/libraries. There might be a change in that with the lockdown at the moment, but that will be updated by the end of the week, I think, for you all. Okay, so enough of me chatting on. I'm going to introduce Tracy, first of all, and she's just going to tell you a little bit about our Business and IP Centre. Thanks, Tracy.
Thanks, Claire. Hi, yeah, so I'm Tracy. I work for the Business and Intellectual Property Centre. We're usually based at Leeds Central Library, but we have taken all our services online, and we've continued to be online since early March. We're part of a national network led by the British Library, and what we do is we provide business and intellectual property information and guidance for the local business community. Although I must admit, since we've been online, we've had some people from America accessing our webinars and from all across the country, which makes it a lot more interesting. But yeah, anybody is welcome to access our services, really. So we provide access to a range of resources in the areas of market research, industry information, company information, British standards, that type of thing. And we can actually access those online from home while we're all at home at the moment. And we can possibly do screen sharing with people if anybody wants to take a look at those. Alongside access to resources, we also do one-to-one sessions, information sessions with anybody who's looking to start a business, who perhaps is a little bit unsure of what they need to be doing or need a little bit of guidance. We also support people with basic IP needs. So if someone comes along to us and they're not entirely sure what IP means to them and their business, we can talk them through the basics. So alongside the work that the team actually do, we also have access to advisors. So we have business advisors, an accountant who comes in once a month, and also we have advisors in the areas of intellectual property, and they run on a monthly basis. So we have 2 organisations that come in and offer free one-to-one advice sessions. At the moment, they're delivered over the phone. In the areas of intellectual property, and we also run a patent clinic once a month. Again, they're all bookable sessions that can be delivered over the phone. They usually only last 30 minutes. Yeah, we offer quite a lot. We also have lots of webinars that we run on a regular basis to support any businesses looking to start in business or to grow and develop their business. At the moment, we're running a program called Reset Restart. It's a national program where we are funded to provide support for any businesses that are struggling during the pandemic, especially if it's new business up to 3 years old. It's a really difficult time anyway for businesses, and then throw a pandemic in and it's an absolute nightmare. So there's lots and lots of free support both through the Business IP Centre and also across our entire network. We promote all our sessions, webinars and one-to-one sessions on our Eventbrite page, so I can ask Claire to send that a link out after this session here. But yeah, that's just a really quick overview. If you've got any questions or you need any information or support, please get in touch with our service and we'll try our hardest to help you. Okay, Claire, thank you.
Thank you, Tracy. Wonderful stuff. So Tracy's really busy at the moment, so she's going to try and listen in, but she's got loads of different other work. But if you do have any questions, please put them in chat, and I can send them to Tracy and then try and send out the answers when we get them. We really wanted to keep connected to you all, and we found that there's so many different discussions and themes within digital, and today I'm really excited to learn a bit more about protecting your digital products, as well as things like if you're an author, that kind of thing, how do you protect your rights to your products. And so today we've got two very experienced and inspiring individuals in Virginia and Tom, and they are both European patent attorneys, and with particular interest in AI, machine learning, quantum computing from Tom, and Virginia has 25 years of experience in the intellectual property profession and has registered thousands of patents as well. So really excited to hear from you both, and I'm just going to ask you to both take it away. Thank you so much for joining us.
Thank you. I think we can skip over the intro slide. Claire's given us a lovely intro. Thanks very much, Claire. We're delighted to be here with Leeds Digital Library. I actually put together this presentation, or a version of it, right at the beginning of lockdown 1. So this is quite a timely day to be delivering it right at the beginning of lockdown 2. And at the beginning of lockdown 1, I read this piece by a journalist in the World Economic Forum. So where it says recent edition, this is actually March of this year. From hands-free door openers that can be 3D printed to basic ventilators, the COVID-19 pandemic has ushered in a new era of urgent innovation. It's reminiscent of the inventions of the Second World War, when the first digital computer and rocket technology came to the fore. And I can certainly say that from March, we've noticed this era of urgent innovation, all sorts of different ideas, different areas of innovative activity, and not just where you would expect them in the fields of the kind of biofields and let's get this vaccine sorted out, but also very much in the tech arena as well. You know, the level of technology, particularly digital technology, AI technology, software technology, that's being developed to support the track and trace, the data monitoring, all these things around COVID, so important. So I wanted to talk today about intellectual property, but given the lockdown theme, you know, kind of from the single person angle, where does intellectual property actually start? So it starts with you, right? You have an idea, you as an individual, and that's where all intellectual creation starts, in your head. It's your idea, so you own it, right? And so crack on, innovate, set up your business, it's fine. But wait a minute. So before you can actually own your own idea, you have to understand what tag you're going to give it for that ownership. And on this pie chart here, you can see 3 different colored areas, and each colored area represents a different type of right, legal right, that you can have, which protects your idea. And without these legal rights, you find your idea will vanish into thin air. And that's a theme that Tom's going to pick up on later on in this talk. But just to go through the various different legal rights that can protect your idea, in the light blue corner, we have registered rights. And these are so called because you have to take positive action to register them. And these are registered designs, patents, and trademarks. In the dark blue corner, we have unregistered rights. So these are rights where you don't have to register them, but you do have to take some affirmative action, confidential information, trade secrets, and know-how. And then in the pink corner, We like these because these are rights that occur automatically. You do just have them. Copyright, goodwill, unregistered designs, and database rights. But interestingly, and taking the individual theme, all of these rights start in some legal wording. And so I'm going to get a little bit nerdy and just go into some of the legal wording that is the source of these rights that are granted to you. Patents, I mentioned patents. So these are a monopoly right. They don't require copying. So if anybody comes up with your idea, even independently, and you have a patent, then you can prevent someone else from using that idea. Or conversely, control who's using that idea. So you might have a patent, you might want to license certain companies or individuals who you feel are using your idea for good, and prevent other people from using it where you feel they may not be so effective. You can protect broad concepts, you're not constrained, and they can last for up to 20 years. So where do these patents stem from? The Patents Act. Patents Act 1977. And in section 7.3, it defines an inventor. Now this is you, you have an idea, but actually, unless you file a patent application, you don't have the legal status of inventor. The notion of inventing as a broad concept has to be pinned down in law. And this is the Patents Act here that tells you what you are. Inventor means the actual deviser of the invention. And if you do file a patent application and you get granted a patent, you get granted a legal monopoly, as I've just explained. Now, patents can be granted for all kinds of things, anything physical, anything concrete, physical device, apparatus, process, product. There are some important criteria. One is it must be new, and the other is that it must be non-obvious. That's just another way of saying inventive, actually, but let's just think a little bit about what new means. For something to be new, it has to be something which is not already in the public domain. And at one level, that makes sense, right? You can't invent something if you read it in somebody else's book or journal and say, well, that's mine, I've invented it. So that makes sense. But as Tom's going to explain later, you could actually put your own idea into the public domain by mistake or unwittingly, and then it wouldn't be new either, even though you were the inventor and it was new when you started. So that's patents. So you can be an inventor under the Patents Act 1977 if you make an invention. Registered designs. So what are registered designs? These are also in the light blue section, a right you have to apply for. A registered design protects the shape or configuration of the whole or part of an article. So basically the appearance of something. And you can be an author of a design under section 2, part 3. And the author of a design means the person who creates it. Now, I chucked into this slide section 2, part 4, because of my kind of interest in AI, and we do a lot of work in AI, a lot of work in digital computing. In the case of a design generated by a computer, in circumstances where there's no human author, the person by whom the arrangements necessary for the creation of the design are made should be taken to be the author. So you still get back to a human person, ultimately, who told the computer what to do, and then the computer made the design. So it's still a human author. But in order for you to be an author under the Registered Designs Act, you have to apply for a registered design. So these are the registered rights in the light blue corner of that pie chart. I'm now going to hand over to Tom, and Tom's going to talk you through some of the unregistered rights, or the rights that you have automatically.
Thanks, Virginia. So the first of these unregistered automatic rights, and probably the one that's most relevant to tech and software, is copyright. Now, copyright, similar to registered designs, has a concept of an author, and it subsists automatically from the moment that the author creates a work that is within one of the categories of subject matter. And because copyright law is a lot older than computer technology, computer programs are covered in the UK under copyright as a form of literary work. Now, in a sense, copyright's fantastic. You write your code, it's there, and from the moment you've put fingers to keyboard, that code is now protected by copyright. It's protected to the extent it's original, which really just means that it's something you've come up with yourself as opposed to having copied from somewhere else. But the problem with copyright is that it is limited. So in the case of software, it is the code of the software that is protected by copyright. It's not the underlying idea behind the code. It's not the concept. It's not the functionality of the code. You can stop someone from copying your code, but that means someone who has access to your code has to have actually copied it for this right to kick in. If a competitor looks at your product, takes your idea and recodes it themselves, that's no longer protected by copyright, and you can't assert your copyright against them in that scenario. Copyright similarly is covered by the Copyright Design and Patents Act 1988. And as I said before, it's under this as a literary work. You can also get copyright in an aesthetic creation, so you can have a situation where you might have overlapping design rights and copyright. And there are similar provisions around computer-generated works. Now, confidential information is another right that subsists. In some sense, it subsists automatically, and in some senses, it very much doesn't. And it's probably one of the most fragile of the rights in that kind of broad intellectual property bucket that Virginia talked about at the beginning. So when you come up with an idea initially, and you haven't shared it with anyone else, no one else has come up with it before, that idea is confidential. No one else knows about it. So at that moment in time, and let's say you've got it, maybe got some notes on your computer or something that you've put down, password protected perhaps, or at least, not readily accessible to the world. You have got a piece of confidential information there. And if someone were to say, come along and hack your computer, you might be able to say, well, that's a kind of breach of the confidential safeguards around that. But as soon as that information enters the public domain through a channel that's not bound by some duty of confidence, that information is no longer confidential. And there are two situations where this can happen. The most obvious one is that you tell someone about it, not under confidence. In that case, the information is no longer confidential, and you don't have this right of confidential information to it. Confidential information is a slightly different category of legal right in that it's not really a statutory right that arises automatically in the way that copyright does. It's fundamentally the protection comes from a kind of a contractual right or a legally binding agreement between one party who is sharing the information and the other party who's receiving it. And that can be an explicit non-disclosure agreement type thing, or in certain circumstances, courts have recognized that there can be an implicit duty of confidence. But there are lots of situations where you tell people something, tell them information, and there's no duty of confidence. They're free to do what they like with it at that point. Any protection you then have at that point is gone under the confidential information umbrella. A particular example would be if you disclosed it to one party initially under an NDA, and then you told someone else not under an NDA. That earlier NDA is now void because it's not the subject of information that is confidential anymore. The other situation where information can stop being confidential is if someone else independently derives it and puts it in the public domain. Again, you might have been the first one to come up with it. You had this idea. You've been really careful about who you share it with in terms of NDAs and everything like that. But there's nothing to stop anyone else from independently coming up with the same idea. And the second they put it in the public domain, it's not confidential anymore. So you don't get any of that protection. Virginia mentioned briefly as well the idea of novelty, and I'm just going to jump back briefly to patents at this point. If you have a piece of information that is initially confidential, it's not in the public domain, and it therefore satisfies that requirement of new at that point of time when it comes to patent protection. It is eligible for patent protection at that point in time if you file your patent application whilst it's still confidential. The second it goes into the public domain, either because you've put it there yourself or someone else has independently derived it, not only have you lost that confidential information protection, it's also no longer new by this legal standard applied to patents. So you can't fix the situation at that point by filing a patent application because it's also no longer new. And I think that's probably the key takeaway really from this talk. So as Virginia said, the sort of theme of this talk is, well, it's my idea, I came up with it, surely it's mine. And what we're really doing by showing you these legal rights, their strengths, but also their limitations, are situations where actually that's not actually the case. And probably the most common example with that for tech companies is a kind of assumption that because you've come up with this really clever thing that was new at the time you derived it, that you somehow are just entitled to that as a piece of IP. And you're not from the moment that it goes into the public domain if you haven't filed a patent application to kind of fill the gap that is being left when the confidential rights go. And I think if there's a golden rule that we could summarize this in, it's that you can destroy the novelty of your own invention to lose both your opportunity to patent it and your rights of confidential information. Now, if you were paying attention, you might notice that there was actually one more registered right in Virginia's initial slide that we haven't covered yet. And this is trademarks. And actually, we've left this to the end because from the perspective of tech companies in particular, or tech innovators, it is a little bit secondary to the other rights, but it is still important to be aware of. So trademarks are really fundamentally about protecting your branding. In fact, the underlying trademark rights are a little bit different. They're originally there to actually prevent confusion as to the source of goods or services. The idea being that you can register a trademark that is clearly indicative that your goods or services are coming from a particular source to stop then other people saying that their goods are coming from that same source when they're not. Now, there isn't really a concept of an author or an inventor for trademarks. When it comes to trademarks, it really is much more of a procedural thing of who actually gets there and files a trademark first. So if you're in a situation where you've done a bit of work, you've done your branding, you've come up with your name, there's two situations that can arise there. The first is that someone else might have already trademarked it. And the second is that they haven't at the point you come up with it and you start using it, but then someone else does come along and trademark it. In both of those situations, the default position is that the person who's trademarked first has the rights to that. There's a little bit of nuance to that in the second situation. If you have established what we call goodwill in your name or your logo or whatever it is, you might be able to get their mark essentially taken off the register and you'd get your own opportunity to trademark it. That's a process that is orders of magnitude more expensive than just registering the trademark and being the first one to register it. And I think that probably takes us to the end of this summary of the kind of various categories of IP and how they might apply to you and your ventures. So questions welcome.
Thank you so much, Virginia and Tom. That's fantastic. Little run through of all the possibilities. So if anyone wants to put any questions, please put them into the chat. We've got one from Sylvia already, and they were asking, so it has to be entirely novel avant-garde invention for you to be able to patent it. So it can't, I suppose she's asking, it can't be similar to anything that's come before, possibly?
Shall I respond to that then, Claire?
Yes, please. Thank you.
Hi, Sylvia. So I love that term avant-garde. So you'll remember on the patent slide we had two kind of criteria. One was new, which we've gone into in a bit of depth because it's just so important, and the other one is non-obvious, which I think is perhaps where your avant-garde comes from. So the new test is just a binary test. So anything that's different, even a small difference, satisfies that test of being new. So compared with everything that's in the public domain, if you've made even a small step forward, that satisfies the new test. Now, the second bit of that test is it obvious or not? And that's a kind of conflagration of legal tests, which are applied in different ways in different countries. The upshot being that it's virtually impossible for a lay person, an inventor, to determine whether or not they're going to satisfy the non-obvious test, because it's applied differently in different technologies, it's applied in different countries in different ways. And it doesn't have to be avant-garde, it doesn't have to be a huge jump. It just has to be something that wasn't in the normal course of engineering. You know, any new solution to a real problem that hasn't been solved before is likely to satisfy the requirement of not having been obvious. But it's really a complex legal test, and so I would thoroughly encourage you, if you have something which is new, to take the opportunity of one of these patent clinics, or email us, or advice from an IP professional to run over, is it avant-garde enough or non-obvious enough?
I'd add as well, actually, that the absolute vast majority of inventions are not the kind of, what you might think of wholly new, groundbreaking. That almost every invention is a combination of new and old. And actually, as well, and the other point to make, it might, particularly with things like machine learning, novelty, new applications of existing technology also satisfy that novelty test and can be non-obvious. So taking a kind of model that's been developed in language processing and finding a way to apply it to images to do something, that gets you over the novelty threshold.
Yeah, I suppose I was looking at the example of like a Dyson vacuum Hoover. Hoovers have been in existence for ages, but the patenting technology of the air kind of thing, that's the novel idea, I suppose, within that. Will is wondering about confidential information and working on something with partners. If you needed someone to help design an element of something, which would mean telling that partner about other parts of the design, would you need an NDA?
Shall I take that one,
Yes.
Virginia?
Yeah.
So the short answer is really, I'd be thinking more actually about other risks as well as confidential information in that scenario. An NDA is definitely helpful, but it's potentially not the best solution depending on where you've got to. So one situation that can arise is that you have a really clear high-level idea yourself of what your invention is. At that point in time, it's pretty clear that it is your idea. If we look at this slide here in the definition of inventor, the inventor in relation to an invention means the actual deviser of the invention. You've devised the invention at that point, and there's no question mark over that because it's just been you. As soon as you're sort of bringing someone else who is an external contractor maybe, or worse, a kind of informal relationship, or someone where there isn't a kind of clear legal relationship between them, not just about confidentiality, but about ownership, you're now into this second piece around joint inventor. And suddenly you've got joint inventors potentially being owned by multiple parties with a lack of clarity around who owns it, and a possible lack of clarity around were you actually the deviser of the original idea. the optimal solution in that scenario is to, at the very least, file a provisional patent application before you start having those discussions with the other people involved. That's the kind of, if you've got the funds to do it and enough of an idea to do that, that's kind of the optimal one. The next best one is to have an agreement that, yes, is a non-disclosure agreement, but it is also an absolutely clear agreement over ownership. So who owns this idea? If it's going to be you owning that idea, what's the sort of, what we call the consideration? What's the kind of commercial agreement that is sort of underpinning that means that you're owning the idea and they're getting some kind of compensation? You might be quite happy to be in a joint ownership situation in terms of, maybe if it's an early company and it's sort of with someone else, you both have shares in the company. But that, again, is a very different situation to you both having shares of it, the idea, as individuals. And in that case, you still then need an agreement to say, well, all of this IP is owned by the single company, and then a kind of separate agreement that says what the shareholding of that company is.
Fantastic. So I suppose the confidentiality will come into play when you're asking advice from one of our business and IP patent sessions, or when they're coming to you as a solicitor as well for advice, so they wouldn't have to worry about that.
That's correct, yes. So talking to a legal advisor, they're bound by their professional code of conduct to keep their clients' information confidential.
Steal your ideas. So have you got any examples of digital disputes on patents or ideas or anything, inventions that you can share with us today? Putting you on the spot there, so don't worry if you don't, Virginia or Tom.
Digital dispute. You are putting us on the.
Maybe not.
We pride ourselves in keeping our clients out of those kind of disputes generally.
Well, so actually, if you think back, one of the biggest digital disputes that has ever taken place actually in IP history was the smartphone wars. I don't know if you or any of you kind of came across those. I mean, they even got as far as normal newspapers, not even just the technology pages of the Times, but even ordinary newspapers were reporting on the smartphone wars. And these were massive patent battles between all of the big companies who owned patents in the field of smartphones. And virtually every company had a patent battle with some other company in that sector. So they were all kind of raging around. And the reason, I mean, that's a kind of big example, but an interesting one, because the patents themselves ranged from patents on the embedded digital technology, for example, around encryption of the packets and transmission technology, all the way up to features on the screen. You'll remember the unlock swipe feature of the iPhone. There was a patent dispute around that. There was also a design dispute around the shape of the iPhone, which was quite iconic when it came out. It's hard to think back to those days, but when it first arrived, nothing looked like it, and they had registered design. So I think anyone who's interested in kind of dispute territory, digging around in the history of the smartphone wars will give you all kinds of examples. We could do a whole talk on the smartphone wars if you want.
I would.
Sorry, Tom, you go.
Oh, I just to give the other side of that. So in terms of the big, multi-million litigation battles of that kind of thing, I mean, that's a tiny percentage of patents that ever get to that point. Much more the sort of particularly the work we do supporting startups, scale-ups. Patents in that context are a business asset that are kind of adding to the kind of headline value of your business and your technology. And the value of those patents to those companies is much more in the kind of negotiations that you might end up getting into, whether it's someone who's asserting patents against you or a potential customer, potential partner, acquisitions, investment. The value of patents to those kind of businesses is quite a long way removed from the expensive litigation that the kind of tech giants might be involved in.
Yeah, it's a really interesting one, I think, the iPhone versus the Samsung ones. And sometimes I wonder, I know that they are protecting their financial assets, but is it always best for the customer? So there's always a change in even the charges or the headphones and things, and you can't plug them in and you have to buy separate things or that kind of thing. So do you think it is always of value to the customer? Is it positive for the customer?
That's sort of almost a commercial question. So picking up from Tom's theme, what's definitely valuable for the customer or the end user consumer is enabling innovation to go forward. So that's undeniably a benefit to the world. And you know, my first slide, you know, that journalist talking about the important urgent innovation, I think he uses that phrase. So it's undeniably better that people are allowed to innovate for the benefit of consumers. And the rights that we've been talking about here are the legal rights that support that innovation going forward. Now, inevitably, there's going to be circumstances where those rights in the hands of the wrong people can be misused. But I think generally that the whole IP framework, which has been set up to support innovation and allow people to own their innovation, generally has a positive impact on consumers. I think that's why the world has it. The recognition of that.
And actually there's also within that, there are a number of kind of legal safeguards to kind of counter the monopoly or kind of potentially the rights, the kind of IP rights of exclusivity. So you mentioned about different headphones or things plugging in. So particularly when it comes to design rights, for instance, there's an exclusion on design protection around what are called kind of must fit features. So if a thing is designed in a particular way with a particular shape because it's got to fit into this other thing, that's now excluded from design protection because it's a functional must fit feature. Again, they aren't perfect. As Virginia says, there are things that are open to abuse. The other big one, of course, is competition law that is there to kind of be the overall kind of balancing things to exclusivity getting out of control. So there are some safeguards, and the courts are generally kind of pragmatic when it comes to doing this, and will weigh up public interest factors as well. But yeah, it's as with any kind of legal rights, there can be good outcomes and bad outcomes as well.
Really interesting subject for me. Sylvia was saying there was a battle in the music industry as well, and yeah, as working in a studio, it's how long you can have samples for copyright and all sorts of things like that you have to take into account as well. Sylvia's also asking, does IP protection have a time limit? How does the international community coordinate IP protection?
So for patents, interestingly, it's now very well harmonized across the world, and it's up to a maximum of 20 years from your filing date. In the tech world, that's actually quite a long time, and actually you have to pay annual renewal fees generally to patent offices to maintain your patent. They get increasingly expensive as time goes on to discourage people from sitting on patents for the sake of it and only maintaining the ones that are of sufficient value to actually warrant paying those high renewal fees. 6 to 7 years is probably more typical as the lifespan of a patent in the tech space, just because the technology will inevitably have moved on by then. For copyright and others, it gets more complicated because it tends to be based on the certain number of years. It's 75 years from the death of the author as a rule of thumb. So they can persist for a lot longer.
And I think, is there something about families as well, and being given them, I don't know, even after the death of an author and things, possibly. Yeah, we have to be very careful with that in libraries, because
Yeah.
we love open source and sharing, and particularly you know, using our collections as inspiration to create you know, new thoughts, new ideas, that kind of thing. But yeah, you have to be very careful. There's lots of different ways that people will put their copyright on. So it might be open source, or it might be you can use it for education, but you can modify it, but you need to identify the author, that kind of thing as well.
And in that role as well, you also have a number of limited but still useful exceptions to copyright around fair use, where actually you can use a copyright work in a certain limited defined way that is then not infringement, even though the work is copyright.
Fabulous. This is very fascinating. I'm learning loads. I hope everyone else is as well. So if you've got any more questions, do please put them into chat. If not, we can possibly finish. I'll give it a couple of minutes, let you have a wee think. So if people wanted to find out if a trademark had already been created or a patent, how would they go about doing that?
So there are search facilities which are available to members of the public, so they're not kind of locked down just for professional use, although some of them aren't that user friendly, so you might want to get the help of a professional to use them, but you don't have to. So ukipo.gov.org, I think, or .gov.uk, I think is the UK IPO website itself offers search facilities that you can go and enter trademark names into, patent owner names, and then there's various different other search tools which are a little bit more complex to use. But it's publicly available information.
That's fantastic. I think the Business and IP Centre can help you with that as well. If you are interested, we've got books going back to the library to the 1900s. They're wonderful, and particularly over the war years they seem to have got thicker and thicker. So like as you were saying, I think there's more innovation in certain decades where people are being forced into creating new products for the world around them, which is absolutely fascinating. So I've got one more question, and I think then we'll end the talk today. How is the ownership of a commissioned work determined, or the ownership of a work made for hire determined? Let me know if you need me to repeat that.
I'm just reading it here. By agreement or assignment, so the commissioner no longer automatically gets intellectual property rights just by the act of commissioning. So you do need to make sure, if you are the commissioner, and in fact I think Tom touched on this in the answer to that question about you know, should you have an NDA if you're talking to a third party. You need to be as wary over who owns the rights, and part of understanding the transfer of rights in commissioning, the non-automatic nature of transfer of rights in commissioning, is really important. Tom, I don't know if you want to add to that.
I think that's right. I mean, it's a hot topic actually. For a while there were differences in the way it worked for different categories of IP and in different countries. There's been a bit of a move more recently to try and make that a bit more harmonized, at least in Europe, but the takeaway means absolutely the same. Don't assume that just because you've commissioned the work, especially if you've not got it in writing, don't assume that you own it just because you've commissioned it. And going back to what I said, you don't want to be in a position where you've commissioned work that it turns out someone else owns, and you don't want to be in a position where you commission work that is jointly owned by two individuals. You are much, much better doing that through a proper company structure to resolve all of those issues and having those agreements in writing.
Fantastic one to finish on. So thank you to everyone who's joined us today for the tech talk on protecting your digital assets and products. It's been absolutely fantastic. Thank you so much to Tom and Virginia for giving your time and your expertise. Absolutely fantastic. Yeah, I hope everyone has a lovely day. We'll send out the links to the recording of this and also any links that were discussed in the chat. And as Tracy was saying, we'll hopefully be doing some more talks with Page White and Farrar as well. So keep an eye on the Business and IP Centre event page and also on their Twitter account as well. So thank you everyone and have an absolutely